Well, I'm honored that Eryn asked me to present on, I'm doing estate planning and creating wills and trusts for lots of friends and neighbors and people in town, and I have been doing that for a couple of years. I graduated from law school at BYU in 2006 and worked for a pension fund for a little while and worked for a patent law firm up in Salt Lake for a little while, and then I had 4 kids and kind of took a step away from that. And now I'm getting back into practicing law and have my own law practice, just part-time doing wills and trusts, but I really enjoy it. I am a member of Wealth Council, the estate planning section of the Utah Bar, the Utah Valley Estate Planning Council. I go to lots of meetings to learn all of the things that you need to put in your wills and trusts. But we're going to talk about some examples of things that can go wrong, why you might want to think about doing some estate planning if you haven't yet, and then the basics of estate planning. So my first example is Etta James. She's a great blues, gospel, jazz singer. And in 2008, she was diagnosed with Alzheimer's. And so her sons thought, well, we better hurry and get a power of attorney so we can make decisions for her. And they were sons from a prior relationship, and her current husband and her children with power of attorney kind of disagreed about how things should go, how much should be spent on medical care, what kind of medical care she should be getting, whether certain things should be paid for or not. And so it ended up in court over this disputed power of attorney. The husband said she'd already been diagnosed with Alzheimer's when she signed that, so how could she be competent to sign it? So that's my lesson number 1 is don't wait until it's too late. Don't wait until you've been diagnosed with Alzheimer's and then think, oh, now it's time to get this in order. Or your kids, that's when your kids will think, oh, we better do something now.
So what's the rest of the story?
What's the rest of the story? So it went to court, and the judge allowed the husband to have control over like $350,000 a year to pay for her medical care that he wanted in-house and people coming. So that was her story. A lot of us don't have $350,000 a year to take care of that, but that's what the outcome was with that. So our next celebrity estate plan that went wrong was a plan that didn't exist. Prince had, he's pretty famous, had a lot of top #1 songs and had a good sized estate, but he died unexpectedly and had no estate plan in place, had nothing outlining who should be his personal representative and in charge of distributing things, had nothing saying where he should have things go. And so it followed the intestate statute, and I think it was 6 brothers, 6 years in probate court to say your brothers get your all of your money and your property. And so, that maybe wasn't who he was closest with, but that's where the judge decided the intestate succession plan should go. And so, also, he had a very large estate, and so he was probably above the estate tax exemption, and so he could have done some planning to avoid those estate taxes or some of the estate taxes, but ended up probably, right now the estate tax exemption is $13.61 million this year. That is going to be a little more next year, and then it gets cut in half at the end of next year if Congress doesn't do anything. I don't know.
Per person or per couple?
That's per person. So you have that exemption, and Jeff has that exemption, and so most people are not worried about estate taxes, but that can change at any time. So get an estate plan in order. Tell the world who you want to be in charge. tell the world who should get what. Take a little control over your estate. I think this is my last one. No, I have one more. This next one is Heath Ledger. So he was a pretty famous actor that died unexpectedly, but he did have an estate plan. He just had put it into place before becoming before he got into a long-term relationship with a girlfriend, and he had his daughter Matilda. But his estate plan left everything to his parents and to his siblings because he had completed it before his daughter was born. If you have minor children, they can kind of elect against your estate plan if you've left them out. But he probably wanted everything to go to his longtime girlfriend and daughter, and then he died unexpectedly before getting that updated. And so his long-term partner wasn't able to inherit, but his parents and his siblings disclaimed their inheritance, and so everything was able to go to his daughter. So that was a good result there. But that's a lesson for all of us, where if you have a big change in your life circumstances, a marriage or a divorce, or children, new children, like Eryn was saying, mostly estate plans will include after-born or after-adopted children. But sometimes you might have a child die, and then you need to update who your trustee or personal representative is in those cases. So they are kind of living documents. If you have a big change in your life circumstances, you'll want to do some updating. Okay, and then finally we've got Michael Jackson. And he had a trust, but he didn't fully fund it. He left out all of the copyrights on his songs. And so all of that had to go through a public probate process to get that transferred to the beneficiaries. Where if you have a trust, you want to make sure you fund all of your assets into the trust so that you don't have to go through that public probate process. You can avoid the court process entirely. You can kind of keep things just between your trustee and the beneficiaries, and you don't, especially if you're famous like Michael Jackson, where there's going to be a lot of news interest, then you don't have to have that out there for the world to see. And then we've got Whitney Houston, and she had a very large estate that said, okay, my daughter gets 10% at age 18 and the rest when she's 21. And that might be okay if you are getting, even $100,000 at age 21 is maybe too much. But I'm imagining millions at age 21, and how long is that going to last your 21-year-old? When in like a trust document, you can set, okay, I want my children to get, a third at age 21 and a third at age 25 and a third at age 30, or spread it out kind of depending on what your assets are that you're expecting to leave, so that money can stay preserved for a longer period of time and help them reach a little bit more maturity before they're able to get access to all of the funds at once. Okay, so this is a good little definition of estate planning. It's being able to control your property while you're alive and able, take care of yourself and loved ones if you become disabled, and then give away what you have to who you want, the way you want, when you want, saving every tax dollar and professional fee and court costs, right? That's our goal with this. And there's lots of different kinds of estate plans, and different estates need different plans. Someone who's young and has no real estate but does have a child or two might just need a will, because they're going to be able to do beneficiary designations for most of their assets, but they want to be able to name a guardian in their will. So anyways, these are the 4 types of estate plans. No planning at all. That's not something I would recommend to anyone. Then there's title-based planning. Sometimes people just want to add a child to their deed as a joint tenant. I don't recommend that at all. Or there are transfer on death deeds, and I have recommended that in some situations where someone just wants something very simple and they don't want to have any contingencies or things like that in case something unexpected happened. Then you might just do a transfer on death deed for your real estate and do beneficiary designations for other things. There's will-based planning that I kind of talked about when I would use that. And then a living trust-based plan I think is really great for anyone who has real estate, anyone who has children. Kind of the differences between wills and trusts, there's a lot of them, but a will, it only goes into effect when you die. So if you became incapacitated, it's not going to have any resources where your trustee could step into your shoes, like with a trust. And so with a trust, if you became incapacitated, your trustee could interact with the bank and be able to keep the bills paid and sell the house if needed to take care of you, whatever needed to be done. With a will, it has to be proven in a public court process, but the trust stays private. The will names a personal representative to handle your money and property, and that's kind of similar with a trust. You would be your initial trustee usually in most cases, or you could name someone else to be an initial trustee. Sometimes that happens with someone who's more elderly and wants to name someone to help with them right away. And then you can provide successor trustees for after your death. And then once with a will, once probate is closed, that's when I sing it. You can file the notice to creditors, and they have 90 days to file any claims, and then all claims are cut off after that. A trust can be, or a will can be revoked or amended. Same with a trust; those are both the same. But with a will, if you do need to use your will to transfer assets, you do have to go through the public probate court proceeding. And depending on whether anyone is contesting the will or whether the will calls for court supervision of the person who is being appointed as personal representative, or if you wait too long. I just helped a lady who waited like 5 years after her husband died, and then she wanted to sell property, but she couldn't because it was in his name. And so we had to go through a formal probate process because she'd waited more than 3 years, and so we couldn't do the informal process. And so it just it's you have to fill out a lot of documents. You have to go before the judge, and it just kind of takes more time. You have to usually hire an attorney. There are forms online that are kind of self-help forms, but you know, it's a complicated process, and so it's a little bit of delay and headache. There might be a lost transaction if you're trying to do a real estate deal and trying to get that done. And so, the other issue is if you own property in multiple states, you're going to have to open ancillary probates in each state that you own property in too, and so that can be a hassle. The living trust it kind of creates an entity. It's a contract between the trust maker and trustee. So at first you're just making a contract with yourself, but then your successor trustees would become a party to that later. It's like a book of instructions. It tells what's going to happen with your property during your life. After your spouse passes, what happens with the surviving spouse, and then what happens after your death. There's also usually instructions for what happens if someone becomes incapacitated. It's also kind of like a picnic basket, so like we talked about with Michael Jackson, where you've got to fund that trust, and he had missed some pretty important assets. You want to make sure you get everything funded into your trust that you want to go, that you want to have the trust, handle. So real estate needs to be transferred into the trust with a deed. You can transfer bank accounts into the trust, and they can be owned and titled in the name of the trust. And then a lot of things like life insurance and IRAs and other retirement accounts, you just do a beneficiary designation, and then at your death, those assets can go into the trust. With a trust, you would still have a will. It would just be a pour-over will. So it's a very short will. It names who your personal representative would be, and it basically says anything that got missed in funding is going to pour over into my trust and be distributed according to the terms of my trust. It also names a guardian if you have any minor children, but you hope you don't have to use that pour over will. And then you would also have a power of attorney. That's a document that names an agent that would make financial decisions on your behalf. You want to make sure that I like to have them effective immediately when it's kind of a general power of attorney, so that you don't have to go to doctors to have them declare you incompetent or unable to make your own financial decisions. That way, if you know you're working with someone you trust, then they can just do that immediately. And it also comes in handy when, like, I went and bought a car and I was able to sign my husband's name because I had power of attorney, just as convenient for things like that. And it should be durable to remain in force if you do become incapacitated. The whole point is to avoid the need for a court-appointed guardian and conservator. And then in Utah, we have the Utah Advanced Healthcare Directive, and that's where you can name an agent to make healthcare decisions on your behalf. And you also can make your wishes known about end-of-life care for things like life support and those kinds of things. It's not the same as a DNR order, like a post order, where a doctor has to sign off on that to say, I don't want any heroics, I don't want any, let me go if something happens. But it is a document that helps provide instructions of what you would want to happen in a situation where you're not able to make healthcare decisions for yourself. And that's all I've got. Thank you. This has been great.